so much.
Thank you, Genevieve. The Sixth Amendment Center is a nonpartisan technical assistance and research center created to help state and local governments in meeting the constitutional obligation to provide attorneys to poor people facing the loss of liberty at the hands of our criminal justice systems. I've been asked today to speak about current legislation on the right to counsel. But to give context to the two most important pieces of right to counsel legislation this year, I want to start talking about the problems those pieces of legislation sought to overcome. And with that, I'm going to start with the story of one poor defendant I encountered while conducting a statewide study of indigent defense in Utah on behalf of the state's Utah Judicial Council, which is the state's policymaking body for the judiciary. During that study, I personally observed a young woman I will call Mary Smith. She appeared in GRANTSVILLE, Utah Justice Court for a status hearing. She had pled guilty to issuing a bad check sometime prior and had been sentenced to attend AA classes and to pay fines and restitution. Though Ms. Smith regularly attended the AA classes, the judge noted that she had yet to put any money towards her fines and restitution. "Are you prepared to pay anything today?" the judge asked. The woman replied, "Judge, I'm here to turn myself in. I'm ready to have this whole thing over with." Somewhat incredulously, the judge asked her point blank if she was seeking to go to jail. Acknowledging that she had no job, no money, and no job prospect, she stated, "I have no chance of paying, so I want to go to jail." Over the next 5 minutes, the judge diagnosed her with depression and established that she was on drugs. Seeking to get her medical and psychological assistance, the judge had her taken into custody. In an interview upon conclusion of the docket, the judge admitted that at Ms. Smith's original arraignment, where the plea was taken, no lawyer was assigned to represent her because she was only getting fines and restitution. Without jail on the table, the judge told me, there's no need for a lawyer. Therefore, when Ms. Smith appeared in court the day I was there, she was not under a suspended jail sentence. When I asked the judge by what authority he just put her in jail, the judge scratched his head and said, "Mr. Carroll, you asked tough questions." Questioned if he thought the defendant knowingly and intelligently decided to go to jail without counsel to advise her, the judge responded, "Absolutely." He believed this despite his assumption that she was depressed and her own admission that she was on drugs. So how is it that in 2016, poor people can still be jailed in the United States with no legal authority and no attorney to advocate on their behalf? The actual denial of counsel occurs most frequently in our misdemeanor courts because people generally think, well, it's only a misdemeanor. But misdemeanors do matter. For most people, our nation's misdemeanor courts are the place of initial contact with our criminal justice systems. Much of a citizen's read's confidence in the courts as a whole, their faith in the state's ability to dispense justice fairly and effectively, is framed through these initial encounters. Although a misdemeanor conviction carries less incarceration time than a felony, the collateral consequences can be just as great. Going to jail for even a few days may result in a person's loss of professional licenses, exclusion from public housing, inability to secure student loans, or even deportation. A misdemeanor conviction in jail term may contribute to the breakup of the family, the loss of a job, or other consequences that may increase the need for both government-sponsored social services and future court hearings, for example, matters involving parental rights, at taxpayers' expense. But denying counsel is not simply a bad idea. It's unconstitutional. In 1984, the U.S. Supreme Court handed down a case called the United States v. CRONIC. CRONIC states that if certain systemic factors are present at the outset of the case, then a court should presume that ineffective assistance of counsel will occur. The first factor that triggers a presumption of ineffectiveness is the absence of counsel for the accused at the critical stages of a case, as defined by the U.S. Supreme Court and demonstrated in Mary Smith's story. But as the U.S. Supreme Court further explained in CRONIC, there may be systemic deficiencies that make any lawyer, even the very best attorney, perform ineffectively. If a defense attorney is either incapable of challenging a state's case or barred from doing so because of a structural impediment, a constructive denial of counsel occurs. The court clearly advises that governmental interference that infringes on a lawyer's independence to act in the stated interest of the defendant or places the lawyer in a conflict of interest is a cause of a constructive denial of counsel. Here's how such government interference worked in Utah. In Utah, all indigent defense services are a function of local government with no state oversight. In the particular Utah jurisdiction from the story, the city prosecutor is allowed to hand-select defense counsel, enter into contracts with defense counsel, set the attorney's compensation rate, approve all requests for experts and investigators, and then decide whether to renew the indigent defense contract in each subsequent year. Obviously, it's a direct conflict of interest to have one courtroom adversary controlling the other, because in this situation, the defense attorney must take into account what he needs to do to please the prosecutor to secure future contracts, rather than advocating solely in the interests of the indigent accused. For the court in question, the indigent defense contract pays the misdemeanor public defender a flat $600 per month to handle representation of everyone determined to be indigent in that courtroom. The contracted private attorney from the story estimated that he handles about 20 such cases per month. This means he is compensated at approximately $30 per case. To improve his income, the misdemeanor lawyer in question sought contracts from other prosecutors too. In addition to his contracted justice court work, this attorney handled representation in the county district court and conflict representation in the county juvenile court too. In total, this attorney handled 423 cases in 2013, including 101 felonies. Totaling all contracts, the attorney was paid $37,200 annually. That means on average, he is compensated just $87.94 for each and every case he handled, regardless of the complexity of his felony and delinquency cases. To put it another way, let us estimate that the attorney worked 40 hours every single week of the year. Under that scenario, the attorney is paid $17.88 per hour. Though critics will admit that earning nearly $18 per hour may sound like a lot of money to the average person trying to scrape by in hard economic times in rural Utah, it is not a lot of money given the parameters of what is required of a practicing attorney. For example, the maintenance costs to operate a law practice in Utah, commonly referred to as overhead expenses, are many. Overhead costs must be paid each month in order to stay open for business, and so the lawyer's take-home pay is whatever amount remains after accounting for office rent, telecommunications, utilities, accounting, bar dues, business travel, and professional liability insurance. As a means of comparison, the Mississippi Supreme Court determined in a case challenging that state's assigned counsel compensation rate that indigent defense attorneys are entitled to a reasonable hourly fee in addition to overhead expenses. Though that case is now nearly 25 years old, the Mississippi court heard testimony from the Mississippi State Bar Association that the average overhead rate in that state was $34.86 per hour at that time, or nearly twice the hourly rate paid to this attorney in rural Utah without taking into account any overhead costs. No attorney, even the most well-intentioned lawyer, can ever provide adequate representation under this type of financial pressure. The lawyer decided the only way to make it work was simply not to staff justice courts in the early appearance dockets, as was the case with Mary. Now, just one more point on this. Any trial-related expenses, experts, investigations, also came out of that attorney's flat fee contract. But happily, the story does not end there. Utah criminal justice stakeholders and policymakers jumped into action when these deficiencies were revealed. Following the recommendations of nationally recognized standards of justice, such as the American Bar Association's 10 principles, most states eliminate the potential for direct government interference with the right to counsel by establishing an independent commission to oversee the defense function. This year, Utah Senate Bill 155 passed on a near unanimous vote and was signed by the governor. What it does is creates a new Utah Indigent Defense Commission made up of members appointed from diverse appointing authorities, so that no one branch of government has undue influence. Specifically, the Utah Commission is composed of 11 voting and 2 ex officio non-voting members. The governor, with consent of the Senate, appoints 9 members recommended by the following: the Utah Association of Counties, the Utah League of Cities and Towns, the Utah Association of Criminal Defense Lawyers, the Utah Minority Bar Association, and the Utah Legislature. The Utah Judicial Council and the Commission on Criminal and Juvenile Justice appoint the other 2 voting members. The principal duty of the new commission is to adopt guiding principles for the oversight and assessment of public criminal defense services that happen to align with the ABA 10 principles. Senate Bill 155 includes the first ever state funding for trial-level public defense services in Utah. On a side note, this isolates Pennsylvania as the only state in America with no state funding of the constitutional right to counsel. The new Utah Commission is statutorily required to develop policies and procedures for how best to disseminate these new monies. However, it is important to note that all local governments are bound by the Commission standards, whether they seek state funding or not. Now, I focused on Utah in this presentation, but I could easily have focused on Idaho, which share many of the same systemic deficiencies as Utah and detailed in a 2010 National Legal Aid and Defender Association report. And like Utah, in March of this year, the Idaho legislature, on a near unanimous vote, enacted House Bill 504, a bill with the express legislative intent of improving the delivery of trial-level indigent defense services by providing funding to counties and creating standards with which counties must comply. The bill authorizes the state's Public Defender Commission to promulgate and enforce uniform indigent defense standards. Additionally, a companion $5.4 million appropriations bill was passed authorizing the Commission to disseminate grants to counties to offset the cost of compliance with the new standards. All Idaho counties must comply with standards without regard to whether they apply to the Commission for financial assistance or not. The hammer to compel compliance with standards is quite significant and very interesting. If the Commission determines that a county willfully and materially failed to comply with Commission standards, the Commission is authorized to step in and remedy the specific deficiencies, including taking over all services, and then charge the county for the cost. And if those costs are not paid within 60 days, the state treasurer shall immediately intercept any payments from sales tax monies that would be distributed to the county, and redirecting those funds to reimburse the Commission for fixing the deficiencies. As stated in House Bill 504, the foregoing intercept and transfer provision shall operate by force of law. Finally, the legislative sessions have not ended in all states. Right now, today, the New York Senate is debating a bill already passed by the General Assembly that will shift the funding of indigent defense services from upstate counties to the state over the course of the next 5 years. New York has already created an Office of Indigent Legal Services that has direct oversight of services in 5 counties that were the focus of an ACLU systemic chronic challenge. The idea is that ILS will expand oversight to all upstate counties as the county-to-state funding change is implemented. Now, the legislative session in New York ends at midnight tonight, so we'll know. But there's the potential for 3 states in a single year to go from county-based systems to state-directed and state-funded systems. That has never happened in the past 50 years since GIDEON. It's a really important year, 2016, and one that we hope the states that still need reform will emulate in future years. Thank you for listening, and I'm happy to take any questions now.
Great. Thank you so much, David. We will all be watching the news in the next couple of days to hear what happens in New York. We haven't received any questions in the Q&A, but at this time I'd like to just pause for a minute to see if anybody has any questions for David. If you do, you can either raise your hand or type them in that Q&A box. Oh, looks like we have one from Jeff Burkhart. Kiara, can you unmute Jeff, please?
Yes, you have been unmuted, so you should be able to speak.
Great. Jeff, are you there? All right, well, maybe we'll come back to that one. Jeff, I'm not sure if you're able to speak or not. It doesn't actually, I'm not sure if you've called in, but if you can't or you're trying to, if you can please send it in the Q&A box, we will then be able to ask it verbally. Do we have any other questions? Looks like, is there one more?
Yes, there's a question from Ernie Lewis. Mr. Lewis, I have unmuted you, but if you would like to ask it verbally. Otherwise, the question is, what other states remain? It says what other states remain that you identified. I know you mentioned 3 states in that last little bit there. What are the other 2?
The other states remaining that need comprehensive reform, is that the question? If so, there's a number, probably the biggest of which is California. California currently only funds state post-conviction death penalty representation. Everything else, including direct appeals and all other post-conviction, is a requirement of the counties. There is an ACLU lawsuit against Fresno County and the state for failure to provide effective representation. But other states that have similar qualities to New York, Utah, and Idaho are states such as Arizona, South Dakota, Mississippi, Pennsylvania, which is a huge one, as I mentioned in my opening remarks. Pennsylvania is now the last state that does not contribute anything to indigent defense services. Washington is similar in nature. They do have a series of state Supreme Court rules that make them a little better off in regards to workload and others. But basically the idea of the state not having any capacity to tell if the counties are indeed doing what they're supposed to be doing in regards to the Sixth Amendment Washington is in that group as well. Then there's a couple others. It's like Kansas, for instance, has a statewide system for appeals in felonies only, juvenile representation, and misdemeanor representation are all county functions without any oversight. So you can start getting into a whole nother set of states that may have some oversight of one piece. For instance, the state of Illinois has a state appellate defender that's state funded, but all trial level services are a function of the county, and there's no state organization whose aim it is to make sure they meet standards of practice.
Great, and Kara Nelson is asking about Alaska. Do you know what their situation is?
I do. So the state of Alaska actually has two state-funded organizations. Indigent Defense is entirely state-funded in Alaska. One handles primary representation, the Alaska State Public Defender, and then the Office of Public Advocacy handles conflict representation and then some of the civil work like termination of parental rights. The interesting thing is the directors of both those organizations are a direct gubernatorial appointee, which means that as governors come and go, you get turnover in the head of those organizations. The other thing is that the directors can be conflicted because if the governor says, for instance, take a 10% cut in funding, they know they either have to take that 10% cut or lose their job and have the governor appoint somebody else that would be willing to do it. So I think there's much to like about the Alaska system, but that's a major problem that still needs to be fixed. There is no commission to appoint directors nor set standards of which the people practicing in the systems must meet.
Great, thank you. And it looks like, Jeff, you are now unmuted, so if you would like to ask your question, please go ahead.
Oh, great. Can you hear me?
Yep.
Yes, we can hear you.
Great. Sorry about that. There was trouble, and I think it was on my end. I was just wondering, David, if you have any other thoughts on New York and the passage of the bill there. I've just talked to a couple people there, and nobody I've talked to seems to have a good sense of the governor's veto or anything like that, and I just wondered if you had any additional insight.
No, I've heard it's a coin flip or maybe even worse than that, whether Governor Cuomo will sign it. My understanding is that a lot of the negotiations taking place right now with some amendments is aimed to try to get enough to override a veto if it comes. So it really is, nothing is secured. I think the fact that the Assembly passed it on an overwhelmingly majority basis is a good sign. But we will know by the end of the day today exactly what's going on. And if a bill passes, then there's going to be a period when people just don't know what the governor's going to do in regards to a veto.
Great, thanks.
Great, thank you so much, David, and thank you all for those great questions. And now at this point, I'd like to turn it over to Nancy Belden and John Russonello.
Can you guys hear me?
Yes, we can hear you now.
Okay, sorry. All right. Okay, I think that you guys need to change to our slides.
Yes, and you have control of them now as well.
Oh, I'm sorry.
You're fine.
What am I doing? Here we go. Sorry.
You're fine.
This is Nancy Belden, and I have John Russonello here with me. And we are happy to be able to present the findings from the first phase of a two-part project that we are doing for the Right to Counsel National Campaign on American attitudes. We are looking to update the findings and understanding that we have based on some old research and other things about the perceptions of what the perceptions that Americans have of the public defense system, of public defenders themselves and the importance of right to counsel. And from that, we will also be developing messages to help build support for the national campaign to try to improve funding and policies around public defense all across the country, much like the things that David has just spoken about. So what we've done so far is 6 focus groups. We did them in Columbus, Houston, and Richmond in April, and we divided people up by their gender and their party affiliation and their race and ethnicity. So we had some white groups, which had separated people by party and by gender. We had a group of African American men and women of all parties, and same thing with Latinos. Although those 2 final groups were, as you might imagine, naturally fell into more of the Democratic and Independent camp. So we're going to go through 7 points of things that we have seen so far that we have digested down for presenting here. And the first one is that the public really sees the right to counsel as very fundamental. They believe that the right to counsel is a key factor in achieving the justice and fair play that Americans really think are part of America, and that defendants need a lawyer to get a chance at that fairness. So they see things both from the point of view of the principle that, you know, we believe in justice and fair play, and they see the practical application of that means that people have to have a lawyer that's able to represent them. Here's what a Latino told us in Houston. He said, "This is America. This is the only country I know of where we assume people are innocent until proven guilty. It's what makes us different and special. The fact that we assume people have rights and the ability to be protected. So it's easy to say, oh, that's not going to happen to me, but you never know when it could happen to you. So I think it's something that a protected right that should be defended." A Republican woman in Houston told us anybody who has committed a crime, they have the right to an attorney no matter who they are or whether they can afford it or not, even if you have a different nationality. I'm not going to read every single quote that we had here, but you can see that over and over again people expressed a high level of interest in having the fairness defended, and that they immediately moved to the issue of that income and affluence should not be the governing principle. The second point is that referencing the Constitution is really helpful, that it's a constitutional guarantee. We found that people really in these groups have very few people could tell us where the right to counsel comes from, where it is in law, where it is that it is in the Constitution. Basically, when we asked people that, we got a lot of blanks. So when they were struggling to answer the question in the groups, a lot of people came up with the idea that Miranda is a piece of legislation that provides for the right to counsel, that's where they would find it if they looked in a law book. So that was really interesting. But when we told people in the groups that it's part of the Constitution and it's in the 6th Amendment, it really established the importance to them. It made it all the more salient. People said things like this woman in Columbus said, at the end of the day, if it's in the Constitution, then we should do whatever we need to do to abide by it. A woman in Richmond said, everybody should have the opportunity to have representation. The states will have their excuse, such as it's not in the budget, we're a small town, we don't have the resources, but it's the Constitution. It's a federal right to do it. Point number 3 is that the federal role in providing the counsel and making sure that it happens is very much, pretty much accepted by the people in our groups, although not wholly. Particularly, the Republicans pushed back some bit on the federal role, almost entirely because of the cost issue, although sometimes too ideologically, yeah.
Two points on the Republicans. The men felt that they didn't want the federal government involved in anything, and some of the women were more okay with the federal role, but worried about the cost to taxpayers.
So let's see if we can't see. So we have a Republican woman here telling us that the Constitution trumps everything. I'm big into letting states make their own decisions, but there are certain subjects in which there's no question the Constitution says such and such, and that's it. Conversation over. A Democratic woman said the Constitution is for everyone in the country, so it should be for the federal government to make sure that those rules are followed. A very typical type of statement from somebody. But then again, you see some of the Republicans push back a little bit. Who's going to pay for it? Republican woman asked. Federal government will make you do it, but will it pay for it? Probably not. And if the state can't pay for it, they can't afford it, then the states are going into debt. Then back on the other side of more supportive, you have some Latino man in Houston saying it's that the Constitution says a person has a right to defense. How many people on death row now have been innocent? I say yes, you have to have the adequate representation. If we need to pay for it, the government, it needs to pay for it. Fourth point, the voters in these groups recognized pretty easily that there would be, that public defenders would be overworked, but they did not arrive at the idea that there's a crisis, that this is really a serious, deep problem. They basically understand that you need public defenders. There's no question that they think there are a lot of poor people and a lot of people who aren't going to be able to afford their own counsel, but they just didn't see it as a big issue, a big hole. We should probably, I'm not going to read everything we have here, so just a couple of things to illustrate that point. This Republican man in Columbus said the majority of crimes are committed by people around and below the poverty line, and they don't have the money to pay for it. So there was that recognition there. Was also the sense that a lot of public defenders are not particularly well equipped, or that they are overworked. If you look at that third quote there, we asked people how they imagined public defenders were, what were they like, and here's a man in Richmond saying, in TV and movies, public defenders are always frazzled, mixing up who they're with and not knowing what's going on. I think we can safely say that you're not going to get as good representation as if you paid for a lawyer. We had a lot of discussion around that they understand that it's inadequate, but as I said before, they didn't really come to the conclusion very much on their own that there was a big, huge hole out there or a big need to do something about it. That was something that needs to be communicated. The fifth point is that as we began to try to talk to the focus group participants, as you all talk to the public about these issues, we found that three things that we put in front of them made a lot of difference in trying to get people to recognize the importance of doing something about the financing and resources for public defense. Training and adequacy of the lawyers themselves, time to do their work, and the resources to support building a defense for their clients were all really important pieces of information that are really good and would be good things to try to communicate. Here are the three statements that we put in front of people in the groups that were the things that what I just said grow from, the things that we put in front of them, and then they told us about, gave us their reactions to them. The first one was, and then again, so this starts to be the educational component where we start telling people, well, this is the situation. What do you think of that? And get feedback. So the first one was that in some instances, jurisdictions have reported caseloads to be so high that defenders average just 7 minutes per case. I think that we can safely say that even if this is an extreme case, when you provide the kind of things that, like this, are the kinds of data that David was talking about earlier, when you demonstrate that to people, they really start to see the problem as opposed to just the system. The second statement that we were talking about is the second one. Many times a person will remain in jail as long as 6 months waiting for a court hearing because he or she is still waiting for a public defender to be appointed in his or her case. We had in each of our groups somebody who either personally had experienced this or had a relative or friend who had this happen to them. And the unfairness of this really does start to build salience for people. And the third one was that indigent offenders' caseloads can range from 500 to 900 cases each, 5 times the recommended ceiling set by the National Advisory Commission on Criminal Justice. Again, the same kind of facts that David was talking about really help to illustrate to people that we have a problem and that they don't really know about it. As this man in Richmond told us, he said, I was not aware that there are not enough public defenders to go around, and I probably shouldn't have been. My wife watches all those court shows. I certainly wasn't aware of some of this stuff. The 6 to 10 months really sticks with me, and the 7 minutes, that's just nuts. We heard this over and over. I was particularly interested in the second quote here that the Republican woman said, it should be innocent until proven guilty. How can you expect to prove someone innocent if you only have 7 minutes? And the African-American woman who said with proper legal representation, many of those people would not even be in jail. So they really get the problem when they start hearing about these specifics. And I think that we would say that in lots of cases, in lots of communications issues with our clients over the years, we've been in the position to say, don't drill down with a whole bunch of facts. Sometimes it diverts from the principal issue. But in this case, it really makes the case. Point 6, relating public defense to other issues may have less impact. What we're referring here to is that we offered a lot of other statements and other ideas to people in the groups. And some of them are helpful. They're not necessarily, they don't go in the wrong direction, but they really didn't drive people to getting agitated about the issue as much as those previous ones that we just talked about, when they actually hear about the inadequacy of time and resources for defense. Some of those things that we tested are the idea that the consequences could be life-altering, over incarceration as an outcome of the weak system, and racial bias in criminal justice system. They're important to a lot of people, but they're not as directly related to public defense. So as we have to be sensitive to these things as we move into our next phase of this research and get closer to developing message to which things can be helpful some of the time, but they're not as compelling. For example, the Latino in Houston told us Shoplifting is normally teenagers. They might be 16 or 17 or whatever. And like you said, it's on their record forever. We're trying to help them at this point, not make a mistake. They're young. We as a society don't have to condemn it forever, and that's what happens when you don't have representation. It was helpful. Yeah. He got this kind of thing is helpful. It's just in the final analysis is not as powerful as some of those other things, but they're helpful. Here's a man in Richmond told us, I think overcrowded prisons are not as much a problem because of improper of legal representation, but the laws themselves. I think the number at this point is over 200,000 people a year getting arrested for minor marijuana possession. It's ridiculous. And that's what's driving this, in my opinion. I don't think it has to do with representation so much as the laws in general. So he's not rejecting the idea that the jails are over and prisons are overcrowded, but that other things might be underlying that more seriously.
We got agreement from all three political types, Democrats, Republicans, and Independents, that there's an over-incarceration problem in this country. There was broad agreement that we're incarcerating too many people. But it was the direct relationship to right to counsel that sometimes didn't make the link.
Yeah, and same thing with the linking the right to counsel to racial issues. This is the final sentence here of this woman in Columbus where she says, this is a bigger issue, racial issue here, bigger issue altogether. 1 million public defenders won't help.
The difference in the racial issue is that there wasn't as much agreement across the board from Democrats, Republicans, and Independents that there's a racial bias in the system. Some of the Republicans refused to acknowledge racial bias in the system at all, whereas most of the Democrats and Independents said there was a racial bias, but thought it was a little bit more complicated to fix it than just fixing the right to counsel issue.
Point 7. We put some solutions, some policies in front of people just to see how far they might go with them, and they were not exactly the same things that David was talking about earlier, but they serve very much well, there are pieces of them on here. So we talked about 4 sets of reforms: setting national standards for states to follow that assure a minimum level of resources are available, setting national standards for the qualifications of public defenders and court-appointed attorneys. So those 2 national standards things. And then establishing oversight commissions that ensure the systems are serving people, and requiring states to assign a lawyer who will meet them within, we had 3 business days in here. People could talk about different times. But we were trying to see how people felt about those kinds of solutions. And we got mixed solutions to some of this.
Mixed reactions. I think there was nothing that was overwhelmingly positive and nothing that was overwhelmingly negative. There was some were more appealing than others, but it was generally mixed.
The idea that there would be standards, however, is really important. So the 2 that I'll go back just here, that we had the 2 that we tested that were national standards for minimum level of resources and for qualifications. That kind of thing starts to make a lot of sense to people. Sure. That was when you get to things like commissions, they start to have reasons why commissions might be political, or they had a bad experience with a local commission. They start to erode, get not quite as interested. The standards are much easier to defend. And practical things like having the standards be that someone has to meet with their lawyer within a reasonable point of time is also helpful. A woman in Columbus told us the concept of national standards is pretty important. Make sure that a person in state A is getting the same representation and the exact things offered as a person in another state does. And you do get, again, from Republicans, some pushback. This man in Columbus told us, I like the idea of national standards, but there's this concern about the federal government being able to come in and tell us what to do. Look how it's worked in some other areas, and it's worked in some areas, not in other areas. Equality is something we all love and desire and want to get behind, but the reality of, wow, that never happens because people in D.C. are so far away, so far removed, there's a disconnect between their policy and situational, whatever else. That equality can't exist. I'm torn in that sense. I understand that fear, even though in my desire is what a working federal standardization would create, even though I know we know from experience that it won't. So people want, even the Republicans want things to work, but they have their classic objections. These are just a couple of comments on the commissions that people could come up with reasons why they might not be so helpful. Unless a man in Richmond said, I have a problem with commissions. They can be very costly and bureaucratic. So this takes us to our initial thinking on message components, which we'll be working on additionally. We try to have in our things that we recommend as messaging something that references a value that's deeply held by the listeners, a definition of what the problem is, and an offer of a solution. So in this case, we're going to be further testing the idea that the value is people accused of a crime in America, regardless of their income, have a right to a lawyer. Established in the Sixth Amendment of the Constitution, it's fundamental to our system of justice. We have a problem statement, which again we'll be working on about how the tens of thousands accused, they're overburdened public defenders, high caseloads, 7 minutes per case, things like that. We'll be testing that sort of a definition of a problem, and we'll be working through that. And then we'll be offering some solution statements, and these obviously could vary by what piece of legislation or policy that you're working on at any one time. But it references, again, that we should all have a national, for example, in this case, a standard of justice for all people. And if we had to boil it down at this point to a 30-second message, we'd say today, the right to an attorney guaranteed in the Constitution exists in name only in many parts of the country where caseloads are so high that public defenders can average just 6 minutes per case, 7 minutes per case. It's time to set national standards to ensure that public defenders and court-appointed attorneys have the training, time, and resources necessary to do their job. Thank you.
Great. Thank you so much, Nancy and John. That was really helpful and really interesting. Before we move on to our last piece of the presentation today, does anybody have any questions for John and Nancy? You can either type them into the Q&A box or raise your hand, and I'll just pause for a minute to see if anybody does. All right, great. Well, thank you very much again. And now, last but not least,
I'm sorry, Genevieve, I don't mean to interrupt, but there is one more question, actually. There are a couple questions coming through. The first one is from Ernie Lewis, and his question is, what is the biggest change you've seen since the last study on indigent defense in the early 2000s?
John?
That's a good question.
Let me say, I think that what we've seen is that there's not a lot of change. There isn't a lot of and we haven't, we haven't done the quantitative yet. So the things that we heard in the groups this time were very similar to, and the levels of lack of understanding to what we've known from before.
I can say probably the only change, and this is probably not related primarily to the indigent defense or right to counsel issue, is there's more of a pushback against the federal government doing things. Right? Some people, we didn't hear as much of that. I think it was about 6 years ago, 7 years ago, when we did the last study, 7 or 8 years ago. So that's the only difference that I can see right now, just from the focus group. We'll look at it more carefully in the polling, but there's more of a pushback against federal government doing anything.
And if any of you listeners have ideas about things that you think, that your hypothesis about what that might be, you should shoot us an email and let us know, because we're in the process now of starting to draft the questionnaire for the survey.
Okay, and it looks like we do have a couple more here. From Andrew Davies, I have, what do you think people meant when they said they wanted national standards? Are they thinking of a document that simply states those standards, or are they really saying they want the services themselves to be standardized nationally?
I'm not sure they made a distinction between those two things. I think their idea of national standards, from what I could tell, would be a standard guideline that the states would enforce.
Yeah, I'm not sure that, I mean, we're the ones that put national standards in front of them. So we define them, you know, the way that I could go back to where we were here. Do I still have the control? Yeah.
Yes, you do.
See, these first two up here, national standards of states to follow and qualifications, that's as far as we went. And as John said, I'm not sure that we really went deeply in, or that we didn't really make people think deeply about this.
Okay, and then I have a question from, I'm sorry, we might mispronounce your name, but Katrin Johnson. And the question is, did any of the panelists have experience with the criminal justice system, either themselves or close family and friends? And if so, did you see a difference in their responses?
We absolutely had people in the groups who had experience, and they, I would say that the groups rallied around them. We had one woman who had herself, she was the classic example of having done something small, like shoplifting when she was drunk. She didn't know what she was doing, walked out of the store with something, and it snowballed into a major thing of her in jail a long time, losing her job, getting her kids going to foster care, et cetera, et cetera. And then in other groups, we had people whose children had been defended by a public defender. And I think that, I mean, those experiences were things that actually did of course color the conversation. People did sympathize with those people, and it did help illustrate the needs and make it real, because everything we proposed and said is fact, you know, that we put out there as ideas were backed up by the actual experiences of people.
The experiences of people expressed by people who had knowledge of the system were very similar to the perceptions or prejudices of people who had no knowledge of the system. They were very similar. For instance, there was nobody who had knowledge, who had been through the system themselves, who said, I had the best lawyer I could possibly have had as a public defender, or somebody who said this public defender didn't care at all about me. They didn't say that. Those two extremes you didn't hear. You heard somewhere in the middle that they were under-resourced and overworked, but they did the best they could, and that was the view of the people who had experience in the system, and it was also the view of the people who had no experience in the system. So that was interesting.
But it was interesting to me that here are groups that are pulled, you know how focus groups are. They're pulled more or less at random from people who are willing to come to a group and take part. They had to fit the requirements we wanted from, you know, they had to be Democrats or Republicans or whatever. But then you get this group of random people in the room, and in every group you've had close personal experiences with this. And which will be another thing that we'll want to look at in the polling, because, for example, we know on lots of things that where you have personal experience, what a difference that makes for attitudes.
Great, thank you both so much. And I think at this point we will move on to Ivan to bring it on home.
Great, let me bring up the slide. So while I'm speaking, everyone, if you could make a note or save this slide of my email address, the campaign's Facebook and Twitter handles, as well as the website, rtcnationalcampaign.org. As you can see from on these various platforms, and as I'm certain you heard today, there is a whole lot going on in the campaign, and it's all very, very exciting. I had the privilege of getting to attend focus groups live and see Belden, Russonello, Strategies in Action, and Nancy and John are really the gold standard, and I'm really thrilled that they were selected for this project, and very much looking forward to continuing to work with them and see the final product come in a few months after the next stage is completed. As far as social media and website are concerned, I would be remiss not to give a shout out to my incredible colleague, Ezra Dunkel-Polier, who is a driving force behind the robust social media campaign that we have been on for several months now as a part of this campaign. And again, I encourage you to follow on Twitter, to like on Facebook, and to visit the website. The website aggregates a host of materials from reports and publications to news stories to organizations' websites and much more. And what I would like to very much encourage all of you on this call to do, and anyone who's not on this call who listens to this webinar at a later date, is to keep in mind that this is about the Right to Counsel Consortium, the campaign. It's about you. It's about your participation. If you've got people in your organization who have written op-ed pieces, if you've got reports, if you've got news articles of interest, whether they feature the work of your organization or are just third-party articles that you think are important to bring to the attention of the consortium members and the general public who's keeping up with what's going on in this campaign, by all means, please send me links so that we can get that up on the website, include materials in the newsletter and on Twitter and on Facebook. This is what we make of it, and I want to strongly encourage you to be sending materials our way so that we can share them with the community of interested folks who are working very hard on this campaign. So thank you, and like I said, all of the information you need to do all the things I just articulated in 3 minutes or less are on the slide in front of you right now. Thank you.
Thank you, Ivan, so much, and thank you everyone who's been listening in this whole time. I know that we're a little bit over, so I understand that some people need to close, but before ending this webinar, I would just like to open up the floor to other consortium members if there are any updates and activities that are going on and people want to share, or if anybody has any other questions, please, either submit them in the Q&A or raise your hand and we will call on you now. It looks like we do have one comment and question here, and I will look to panelists if you guys want to maybe take a stab at this one first. Lauren Johnson says, I just heard from a friend of mine in Washington State that the people there who need appointed attorneys are charged as much as $10,000, and especially in the instances when those people go to prison. The state adds hefty interest charges. How can we fix that? David, let's start with you. David, do you have any thoughts on that question?
Well, it's a big problem in our country. The attempts to have the poor carry the funding for the right to counsel through these types of recoupment programs. I'm not so sure the numbers get up to 10,000. That may be what it's called a partial reimbursement, where someone's been determined to be partially indigent, and if it's a significant felony case where representation is several tens or even hundreds of thousands of dollars, it might be something like that. But that doesn't change the question, which is when someone's indigent, they shouldn't then have all these fines and fees assessed on them, including their cost of representation, because it becomes a spiral where they're then jailed for failure to pay, and they get a whole other set of charges assessed on them. We need to realize that when someone is declared indigent, they're indigent. And the best way to do that is to have challenge it through litigation, but also build structured indigent defense systems where the defense attorneys are free to advocate in the interest of the attorney, including fighting the costs of reimbursement if the person can't afford it or simply not have these types of recoupment programs out there. So it's a combination of continuing to challenge the system through litigation, but also doing system building so that states have truly independent systems to fight these problems on their own.
Great. Thank you so much, David. And it doesn't look like at this time we have any other questions or comments. So once again, I just really want to thank our panelists for taking the time out of their day to share all this information with us, and also thank all of you for staying on the call the entire time and participating in the webinar. If anybody has any other questions, please feel free to reach out to us at the Justice Programs Office. As you can see right now, our project contacts are Preeti Menon and Kim Ball, and their email addresses and phone numbers are there. You can also email the Justice Programs Office here at justice@american.edu. And thank you again so much. If you could please participate in the survey at the end of this when you close out. It should only take a minute or two, and that would be very helpful as well. So thank you so much, and have a wonderful day.